Good morning, I'm Tom Schmidt again from the Florida Injury Law Firm. We've talked about in previous segments what we have to prove in automobile cases and premises type cases. In auto cases, we had a few segments where we talked about 3 elements. In the premises cases, I've done a segment that talked about all elements, but primarily on the duty and the breach. Today I'd like to talk to you about causation and damages, especially causation. I'll talk about damages in another segment. But causation of injuries or damages in a premises liability case. It's much the same as in auto cases, although we find in slip and fall premises type cases, people can be really badly hurt by what would appear to be a simple fall. We're looking for spinal injuries, of course, fractures, which are obvious, but oftentimes people hit their head. So we look very carefully at whether or not there's a potential head injury, traumatic brain injury, concussion, that type of thing, from a slip and fall case. Again, nobody assumes that these injuries are caused by the accident. We have to prove they are. With a fracture, not that difficult. Spinal cases, extremely difficult, and it takes a lot of skill and experience like we have at the Florida Injury Law Firm to prove that your spinal injury is caused or aggravated by this particular incident. We don't even need to talk about brain injuries. That is a field that takes absolute specialty, something that we have here at the Florida Injury Law Firm because we've handled dozens of brain injury cases. I personally have over the course of my 30 years, and we do that very well. We'll talk about how damages are calculated in another segment, but suffice it to know that in a premises liability case like other negligence cases, we have to prove causation. We can't assume the damages. Call me. I'm Tom Schmidt at the Florida Injury Law Firm, 407-566-2210.